6 acres of property, which is subject matter of a grant in 1974 in favor of
Oh, this is a Kargil thing.
Yes.
All right.
In
Yes.
favor of an ex-military man. Then he dies, his wife files an application, it should be pursued further. Then the grant order is issued. Thereafterwards, when the computerization takes place, this is subject matter of proceedings under section 136(3) before the Deputy Commissioner as to whether the grant is genuine or not. Deputy Commissioner passes an order saying that this grant is genuine because all the records are there. This is number one. That order has become final. Then what happens? The disturbance is caused by third parties, that is, who claim themselves to be the villagers and also the state. Suit is filed in notices are served, state doesn't represent itself, private parties represent themselves, so suit is decreed. That decree is not under challenge. So 2022, there is a suit which is decreed in my favor, and the proceedings under 136(3) is culminated saying that this is a genuine grant.
All in your favor.
Yes. I am also before this honorable court seeking for enforcement of those orders. Now, three persons, very important, milords.
Petitioners here.
They are the vendors of the person who now seeks the vacating of stay.
Who is the complainant here?
Milords, complainant is one. He purchases this property from on 16/5/2024. This is when actually the problem starts. See the area of parties in this. These are the proceedings under section 136(3). This matter was considered in extenso, notes by holding that there is no grant in their favor. All documents which they are now showing are bogus documents. By invoking the provisions under 136(3), I hereby declare the claim made by respondents over the land bearing no genuinity of the grant relied upon by them. This is the finding recorded.
You are also a grantee. They are also claimed to be grantee.
Yes.
Now, your grant is held to be genuine. Their grant is held like
in
this.
the revenue proceedings under 136(3), there is a civil court decree in my favor.
This become final.
This is subject matter of challenge and order of status quo is granted. Now the question is this, milords. Who is the complainant? He enters into an agreement on 1/4/2024 pertaining to this very property. And after he purchases the property, he files a complaint, which is subject matter of challenge, milords, before this honorable court. Kind of have I am
counterfeit government seal.
Yes.
Okay.
I am the absolute owner of property measuring 7 acres, 20 guntas, 105 total. Are the vendors. The writ petitions pending filed against these above persons wherein they have produced some photocopies of fake documents, produced the certified copies in the suit. Suit documents fake. Upon verification of the case file in 42/22, in the pending branch in first additional civil judge, it became clear that above persons have played fraud on the court by faking, creating seal and documents and filed collusive suit to get the certified copy of the fake documents from the civil court, producing it as evidence. Then, the above said persons are not having original documents to prove that the land was granted to them. Therefore, they have created counterfeit government seal and put the counterfeit seals on the photocopy of the fabricated documents. And bogus documents which are having counterfeit seal is produced as certified copies in the said suit as evidence, as if it is issued from the office of the Tehsildar. Judgment is passed in favor of the plaintiff. Now, the above mentioned persons have taken certified copies of the exhibits and trying to take the return of the documents from the court file so that the proof of the counterfeit seal which is used on the documents and the very documents which are forged will not be available for future scrutiny. If the original court file is taken out from the court records and destroyed, it is difficult to prove the offence. The above said persons have created bogus grant documents with an intention to grab the land, measuring 6 acres in survey number in collusion with the Deputy Commissioner. This is to be marked, milords, that they have obtained an illegal order as well, under, which is under challenge before the Honorable High Court.
What is challenge before this?
The order under which it is held that my grant is genuine.
That is challenge.
Yes.
What happened to the challenge?
There, milords, an order of status quo is granted regarding the revenue entries, which is presently standing in my name. Now, if these are the nature of proceedings which is already pending either in the civil suit or before the Deputy Commissioner concluded, which is one is against them, which is the one is against in my favor, matter is now pending at large before this honorable court. Unless this honorable court decides upon the matter one way or the other, where is any question? And what the allegation is that whatever documents we have filed in the civil suit, all of them are counterfeit documents. This is filed by the Tehsildar for forgery and fabrication of their grant records.
What happened to this crime?
This is pending.
This is where you submitted that grant was held to be genuine.
Yes. Above circumstances, I am of the view that the grant in favor of the husband of the respondent over the land in question is genuine. As he has died in 1980, the respondent and the children, being the legal ends, are entitled for transfer of the entries in the. Where is any question of any crime? And the police have arrested the son, and the direction was given that the bail proceedings should be expedited. Release is okay, but this is the kind, milords, with which the police are being misused. Ultimately, milords, these are subject matter of a scrutiny by the judicial proceedings. There is something called as issue estoppel, which binds all the parties.
Police.
Milords, it is so far as the parties are concerned. Milords,
all the parties. Police.
But not the police.
I'm speaking about the parties, milords. So far as the parties are concerned, there is something called as issue estoppel. They don't have a grant.
Our issue
And this is the matter, milords, where they now say that the interim order requires to be vacated. Ultimately, my lords, this is purely a dispute which is in relation to the grant which is claimed by me and grant which is claimed by them. This has undergone scrutiny at two levels.
But I am not addressing not on the basis of whether he is not owner of the property or not I am owner.
That is pending before the.
That pending not before different authorities. I will only not address to your lordships, but the allegations in the complaint, whether the documents on which not they rely upon are not genuine or not. Your lordship may kindly not have a look at the petition, not page 81 is the judgment not in favor of the accused. Now, this was suit filed in 2022 for injunction.
Against whom?
Not against, not the respondent or defendant 1 and 2,
Who are they?
government or Tahsildar, the state and Tahsildar, the defendant 3 and 4, not they are according to strangers, not what documents.
Suit is decreed.
Suit is decreed because not the defendant 3 and 4 say, no, we are sorry, we are not going to interrupt their possession. Not the
Alright.
suit is decreed. Now, kindly I will look at my first submission to your lordship is not when I make an application not before the authorities who are said to have issued not certified copies of these documents. Not your lordship. None of these documents are in original. I'll just not-
But how is it held that everything is genuine in those?
But some third parties say what their claim throughout is that the father not as ex-army personnel. Therefore, on the ground that he is an army personnel, land has been granted.
Grant certificate.
This is they have only produced one sheet. This is not a letter said to have been returned from the office of Special Deputy Commissioner Bangalore to Army.
Type of.
Returned to the major office, major officiating second in command, officiating command so and so, that the application applied for grant of land in as the deputy commissioner may be requested in the matter, signed either the endorsement not issued by the army or special DC must be not bogus, or application not must be not fabricated. If there is occupation of land applied for the year which it was occupied, not it say not applicable. That means they say we are not in occupation of the property. Total extent of land under occupation on not applicable. They say we are not in occupation of any property. Now this is their document. Now in the application for vacating that I have filed.
Yes.
Now this is the copy of the exhibit P1. They rely upon a report dated in 15/4 and issue a document dated 8/4. Post dated report. Now he was in service from 29/6/1965 up to 30th of June 1980. Therefore, there is absolutely no question of not the applicant not being in unauthorized occupation of this land. This is a local inquiry reveals that he is resident of so and so, so and so. The above said person is cultivating the land for more than 10 to 15 years. He is in service. The villagers have no objection to dispose the land to the cultivated person, bona fide agriculture. As per L&D scheme, the proposal is to be limited to the landless persons only as per said government order. I brought to your lordship notice exhibit P3, early 8/4 antiತ್ತು. Signature 8/4 ಇದೆ. Referring to a document dated 15/4. That is not number 1. This number 2, not they go to the further extent of not forging this. They may not somehow it is seen as 18, not 8. Document this not my submission is this is further forgery. When your lordship compares not page 96 of the document, same document produced by me along with an application for vacating stay and not this document.
ಈಗ ಸಿವಿಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ
Civil proceedings not
ಇದೆಲ್ಲ ಏನಿಲ್ಲ.
No, this cannot be addressed, not in civil proceedings. Not will litigate, will not shock out or remedies not in the civil court as well as not in the revenue proceedings. Not therefore, not these documents would prima facie indicate not the documents exhibit P1 to 4, apart from various other documents on which they rely upon in the civil suit as well as not in various other proceedings. Not they are all prima facie, not appears to be fabricated.
Heard the learned senior counsel appearing for the petitioner and counsel people representing the respondent. I list the matter for further hearing. Both the matters.